In 2020, as Ohio Solicitor General, you filed an amicus brief in a Supreme Court case that asked the court to challenge the administration of the 2020 election in Pennsylvania. The president has now issued an executive order to overhaul our nation's elections and assert federal control over state-run elections. Minnesota and 18 other states sued and won a preliminary injunction. Do you agree with what the judge presiding in that case wrote? He said, or she said, the Constitution does not grant the president any specific powers over elections.
So, Senator, I can't comment on, as a judicial nominee, on any pending litigation. And as you described it, it sounds as though this litigation is pending, so I believe I shouldn't say anything.
Okay. I will note that you did sign this brief, and I'm reminded of one of our colleagues said when we had a nominee in front of us, Caitlin Halligan, where questions were raised of a brief she filed as Solicitor General in New York, and one of our colleagues said, some of our colleagues have argued that we should not consider this aspect of her record because at the time she was working as the Solicitor General of New York, but no one forced her to approve and sign the brief. And I think that we should consider that as we look at your record. Mr. Schwartz, President Trump has claimed I have an Article 2 where I have the right to do whatever I want as president. He has said, I have the right to do anything I want to do. I am President of the United States. Do you believe that the President is able to do anything he wants to do?
So, Senator, without commenting on those specific words, and I don't know the context for them, we obviously have a constitutional system of checks and balances. The executive branch is obviously very strong in certain areas and has tremendous amounts of power and discretion. And in other areas, the other branches have power and discretion, and there's a balance amongst them. So, Senator, without knowing the context of that, I really couldn't comment further on it.
Okay. Mr. Flowers, as Solicitor General, you defended Ohio's law that banned abortion before most women know they're pregnant at just 6 weeks, which included no exceptions for rape or incest. And as you know, a 10-year-old girl in Ohio got pregnant when she was raped. Following her rape, she couldn't get the care she needed at home. And because she was 3 days past Ohio's 6-week limit, and there was no exception for rape, so she had to travel to Indiana to get access to abortion care. You urged the court to lift a trial judge's preliminary injunction of Ohio's abortion ban, arguing each day the law was enjoined, it inflicted, quote, irreparable harm, end quote, on the state. Do you believe that this girl and other women in the state who were impacted by the law suffered irreparable harm?
Senator, anyone who's raped, and particularly a child, suffers irreparable harm. There's no doubt about that. As Solicitor General, my job was to defend the laws of the state, and if I had a good faith basis for doing so, I would do that. And again, that was true regardless of whether the law had a liberal or conservative valence. I defended them all when we had a valid constitutional basis to do so.
Well, given that you argued the court should uphold Ohio's law a full year after this incident with this 10-year-old Ohio girl who was raped, what would you say to litigants who question that you can be even-handed in applying the law, including to women trying to vindicate their rights?
Senator, it will be my top priority to ensure that litigants, as I said about Chief Judge Sutton, recognize that I'm fairly considering the cases that come before me. In the case to which you're referring, when we argued for irreparable harm, we were relying on a doctrine that says that when a state law is enjoined, that is per se irreparable harm. So all I was doing was advancing settled legal principles as applied to that case.
I think a judge's job is to apply the law to the facts, and I'm just looking at the facts of that case. And I think most people would believe that it was the girl suffering irreparable harm. Mr. Flowers, you've argued that timidly, those are your words, timidly, following the principles of textualism and judicial restraint is, quote, unacceptable for the conservative movement of today, which seeks to reverse, not just arrest, our national decline. A movement that wants to kneecap the administrative state will not be satisfied with a court content merely to erect some hurdles. What agencies do you want to kneecap?
Senator, I didn't say that I'd want to kneecap any agencies, and I couldn't express views on policy matters anyway. What I was addressing in that article was particularly the Supreme Court and certain resistance to textualism among some younger attorneys that I was meeting at law schools. I was not saying that those are my personal views.
But is the quote not a movement that wants to kneecap the administrative state? What is the administrative state if it's not agencies of the United States government?
So, Senator, I wasn't describing my views. I was saying that for the people who wish to curtail the administrative powers, they would not be content with a certain approach to textualism, and I was speaking only about the Supreme Court. As a circuit nominee, I'd be bound by precedents of the Supreme Court, and I'd faithfully apply them.
And I just want to note one agency, the FTC, helps enforce our antitrust laws, something I care a lot about, as does the chairman. And it has put millions of dollars back in Americans' pocketbooks. In 2024, the FTC returned $337 million to refunds in consumers. It's just one example. When I hear the words from a nominee that they want to kneecap the administrative state, and that is not to say we don't need reforms and laws passed to make things work better, but to me, that just makes me really concerned of impartiality when it comes to a judge.
This hearing was officially about judicial nominations. But underneath the discussion about legal briefs and constitutional doctrine was a much bigger question now shaping the federal judiciary itself. Are judges simply neutral interpreters of the law, or are judicial nominations increasingly becoming ideological battles over the future direction of the country? Senator Amy Klobuchar approached nominee Matthew Schwartz and former Ohio Solicitor General T. Elliott Geyser Flowers with a strategy focused less on technical qualifications and more on judicial philosophy, executive power, abortion rights, and the modern conservative legal movement. From the beginning, Klobuchar framed the hearing around presidential authority. She referenced statements by President Donald Trump claiming broad Article 2 powers and asked whether presidents can effectively do anything they want. That question matters enormously in the current legal environment. In recent years, the Supreme Court has heard multiple major cases involving presidential immunity, executive authority, administrative power, election administration, and separation of powers disputes. And since Trump's return to office, those constitutional debates have only intensified, especially after recent Supreme Court rulings expanding presidential immunity protections for official acts. Those decisions have dramatically reshaped public discussion about the limits of executive power and the role federal courts play in constraining presidents. The nominee's response was cautious and highly judicial in tone. Rather than directly criticizing Trump's remarks, Schwartz emphasized constitutional checks and balances and the distribution of power among the branches of government. That restraint reflected a long-standing tradition among judicial nominees. Avoid commenting directly on politically charged controversies likely to appear before courts. But Klobuchar's broader point appeared to be this: judges are no longer operating in an abstract constitutional environment. They are being nominated into a period where foundational questions about executive authority are actively contested in real time. The hearing then shifted sharply toward abortion rights. Klobuchar focused heavily on Flowers' defense of Ohio's 6-week abortion law, particularly after the widely publicized case involving a 10-year-old rape victim who had to leave the state to obtain abortion care. This section of the hearing was emotionally and politically significant because it highlighted the post-Dobbs v. Jackson Women's Health Organization legal landscape. Since Dobbs overturned Roe v. Wade, abortion policy has shifted dramatically back to the states, creating a patchwork of laws across the country. Strict bans in some states, broad protections in others, and ongoing litigation almost everywhere. Klobuchar's questioning reflected growing Democratic concern that judges tied to aggressive abortion restrictions may not fairly evaluate future reproductive rights cases. Flowers defended himself by arguing that, as Solicitor General, his role was to defend state law when a good faith constitutional basis existed. That defense is institutionally common. Government lawyers frequently argue positions on behalf of states or administrations regardless of personal views. But Klobuchar pushed beyond professional duty and into judicial temperament itself. Can someone who defended such a law still appear impartial to future litigants? That question revealed one of the central tensions surrounding modern judicial confirmations. Increasingly, Senators are not simply evaluating competence, credentials, or legal skill. They are evaluating ideology, worldview, institutional philosophy, and likely future rulings. And that trend has accelerated sharply in recent years as courts become more central to battles over abortion, voting rights, executive authority, immigration, administrative regulation, and civil liberties. Then the hearing moved into another highly consequential legal debate: the administrative state. Klobuchar quoted prior remarks discussing efforts to kneecap the administrative state, then asked directly which agencies Flowers believed should be weakened. That phrase is extremely important in modern constitutional politics. The administrative state generally refers to federal agencies responsible for implementing and enforcing laws, including the EPA, FTC, FDA, SEC, Labor Department, and countless others. For decades, conservative legal scholars and judges have increasingly argued that federal agencies accumulated excessive power beyond what the Constitution originally intended. Those arguments have gained major traction at the Supreme Court, especially through recent rulings limiting agency deference and expanding judicial scrutiny of federal regulations. Klobuchar framed that movement as potentially dangerous to consumer protections and public enforcement systems. Flowers responded that he was describing broader intellectual debates within conservative legal circles rather than necessarily advocating personal hostility toward agencies themselves. But the exchange highlighted a deeper reality. Modern judicial nominations are increasingly proxy battles over the future size and power of the federal government itself. One of the most revealing aspects of the hearing was how frequently both sides invoked impartiality. Klobuchar repeatedly questioned whether litigants could trust nominees to remain even-handed on deeply divisive issues. The nominees repeatedly responded that judges must apply precedent faithfully regardless of personal ideology. That divide matters because public trust in the judiciary increasingly depends on whether Americans view judges as neutral constitutional interpreters or political actors in robes. And that trust has become increasingly strained as Supreme Court decisions reshape major areas of national policy. What this hearing ultimately revealed was not just disagreement over one nominee. It revealed how federal courts themselves have become one of the primary battlegrounds for America's biggest unresolved political and constitutional conflicts. Because today, judicial nominations are no longer viewed merely as staffing decisions. They are viewed as long-term battles over presidential power, abortion rights, agency authority, election law, and the meaning of constitutional governance itself. And that is why hearings like this now carry consequences far beyond the courtroom. What do you think? Should senators evaluate judicial nominees primarily on legal competence and precedent, or should broader ideological and constitutional philosophies play a major role in confirmation decisions? Leave your thoughts in the comments below. And if you value long-form congressional analysis that goes beyond headlines and examines the constitutional, political, and institutional battles shaping Washington, subscribe to Capitol Oversight for more deep oversight coverage and hearing breakdowns.